So today we are absolutely thrilled to be joined by Bill Hebel, lead client rights officer at the Adams Board of Cuyahoga County. Bill has worked in the behavioral health field for the past 15 years, spending much of that time in advocacy focused roles. He holds a master's of social work degree and has served in a variety of positions throughout his career, including program director and clients' right officer for a consumer operated agency, board chair of the Division of Senior and Adult Services Advisory Board, and as a member of the Adult Protective Service Collaborative, a multidisciplinary team dedicated to advocating for older adults. Bill has served on the Adams Board for almost 9 years and currently serves as the lead client's right officer. And in this role, he advocates for clients across the behavioral health continuum and has extensive knowledge of the Ohio Administrative Code, the Ohio Revised Code, and the federal regulations that guide behavioral health services and protect client rights. Bill is passionate about advocacy and helping individuals understand their rights, and we're very grateful to have him here today to share his expertise. So please join me in welcoming Bill.
Excellent. Thank you so much. Good afternoon. How is everyone? So I see some friends in our crowd today. That's exciting. Some folks I know, some names I know. Really, really exciting. So first of all, a huge thank you to NAMI for the invitation to be here with you all this afternoon. Again, my name is Bill. We're going to spend some time this afternoon, going over client rights. We're going to talk about some of the administrative codes, things that we should be looking for with regard to client rights. If at any point you have questions, we want to make this as interactive as possible. Please put them in the chat. I know our wonderful NAMI hosts are going to kind of help me monitor the chat. We're going to have some time for question and answer, at the end of the presentation. So please, any questions you have, please feel free. So just to kind of get us started this afternoon, I wanted to talk just a little bit about the Adams Board for anybody that may not be familiar or may not know exactly what we do. So we are the Alcohol, Drug Addiction, and Mental Health Services Board of Cuyahoga County. We are responsible for the planning, funding, monitoring, and oversight of a variety of behavioral health providers in Cuyahoga County. Under Ohio law, we are one of 50 boards that coordinate the behavioral health treatment system in our county. Every county in the state of Ohio has an Adams board. So per state of Ohio law, we're the ones that kind of help facilitate making sure that services are accessible to the clients in our county. We are a quasi-independent part of county government. We're governed by a volunteer board of directors, and then we contract with agencies that provide the direct service. And our mission and vision is here for you. I won't go over those directly, but this presentation will be available. Anybody that wants to learn more about our mission and vision. So as far as what we do at the Adams Board, as far as client rights. So in my role, I serve two primary functions within the board. The first is the customer service piece. I am one of the primary public faces of the board. So anybody at all, any community member, a client, a family member, a provider in the agency, anybody at all that has any kind of questions about services, looking for information, looking for resources, looking for information about client rights, anything at all can call the Client Rights Division and have a conversation with us, and we can talk about available resources or what we can do to help the individual. The other part of my job, and probably the one that we're going to spend most of the time talking about this afternoon, are investigating allegations of client rights violations. So any client that either applies for or receives a service in the behavioral health system is guaranteed a set of 21 client rights per the Ohio Administrative Code to make sure that the service that they're receiving is as exceptional as it can possibly be. If a client, for any reason, feels that their service is lacking, that they are being treated poorly, if they're not receiving adequate service, they have the right to file a grievance with the Adams Board. We will investigate that grievance and then issue findings and a resolution to the client to make sure that their issue is corrected. It is noteworthy that we at the Adams Board, we don't provide any direct service. So we will work with clients, family members, community members, whomever, to make sure that they have access to the resources. We won't provide them directly through the Adams Board. So kind of like we already talked about, any client right or any client that receives services in our system is guaranteed 21 rights under the Ohio Administrative Code. Now, I know nothing is more fascinating on this earth than reading through the Ohio Administrative Code. If you've never done it, highly recommend it. It's fascinating reading. I'm kidding. It's really not like any laws. It's very dry, but Ohio Administrative Code 5122-26-18 is all things client rights. So if you're ever so inclined, that administrative code is available for you to review. This code applies to any entity that is certified by the Ohio Department of Behavioral Health. So if you are an agency that provides any type of clinical or certified service, then your agency is certified by DBH, meaning at the Adams Board, we have the authority to investigate allegations of client rights violations, even if we don't contract with that provider. So we kind of already talked about this. We do often work cooperatively with the state and other entities, to assist us in our investigations when necessary, depending on the allegation, depending upon the type of facility that's being interviewed. So one thing to keep in mind as we're having our discussion this afternoon, what you're going to notice with a lot of the client rights that we're going to discuss, a lot of them are born out of a client's perception of an interaction that occurred with their provider. Clients have expectations of how they would like to be treated when they're applying for or receiving service. So even if an agency did not intend any harm or did not intend to act in any kind of untoward way, it can still be a violation of client rights. So that's why when we talk to providers, we always mention, making sure that we're, being mindful of our communication, that we're being respectful, that we're being courteous. And we're going to talk about all of these things in detail. So the next series of slides, we're going to get into all 21 client rights. We're going to talk about them in detail, what they mean. And please, like I said, put questions in the chat. Make sure that this is as interactive for you all as possible. So the first right that we have here is the right to be treated with consideration and respect for personal dignity, autonomy, and privacy. So what this right means, and this is probably the most frequent allegation of client rights violations that we receive. Almost every investigation that we do, the client has alleged in some way that they were treated inappropriately, by their provider or by a staff member. So making sure that when we are communicating with clients that we're always doing so respectfully, that we're always doing so courteously. Obviously, we're not name calling. We're not using any kind of coarse language or any kind of verbal abuse, any kind of rude gestures, even something as simple as the absence of a common courtesy. If I'm walking down the hallway in the morning and I see a client and they wave and say, "Hey, Bill, good morning," and I just keep walking past and ignored them, technically speaking, that's a violation of client rights. They have the right to be treated with courtesy and respect. Obviously, we're not going to shame or embarrass or ridicule our clients. And then something to be mindful of is lacking professional language or using jargon. Anybody that's been in behavioral health, we love our acronyms in this field. We have letters that mean all kinds of different things, and all the different slang terms and different things that we use for different programs. And that's wonderful. It's a great way, great thing that we have to be able to do that. We have to make sure when we're communicating with our clients that they understand what we're talking about. So making sure we're not using all of that in industry jargon, that we're explaining things in a way that's appropriate for the client's understanding. All right. Clients have the right to reasonable protection from physical, sexual, or emotional abuse and inhumane treatment. So when I do this training with our client rights officers and with other agencies and things like that, I kind of have a little rudeness that I use when I say this. So I'm going to use this example here, and I apologize in advance if this comes across as cold or rude. Under no circumstances is it ever appropriate for a staff person at any agency to have a romantic relationship with a client. I don't care if the staff person is lonely, join a dating app, go to a religious service, go to the club, go to the park, go do anything else other than date from your client pool, please. It's frustrating how frequently these inappropriate relationships happen. So we always put this out as a disclaimer. Never is it okay. You will get caught. If you are licensed, you will lose your license, which will prevent you from being able to work in this field. Please don't do that. That's very easy not to do it. Simply don't have romantic relationships with your clients. Okay, so public service announcement done. Also, what this right talks about is we're not engaging in any kind of fraud, corporal punishment, financial exploitation, unless you are a certified payee service, which the Adams Board contract or the Adams Board is aware of three: Murtis Taylor, Smile Payee, and Class Inc. Unless you work for one of those payee services, you should never be managing money for our clients. You know, don't hold their debit cards. I've had a case where we had a staff member that was listed as the beneficiary of a client's life insurance policy. Please don't do that. And even if it's well intended, you know, we do have some of our folks that, you know, maybe our clients have a substance use disorder and they're using their funds to, you know, purchase things that we think are harmful to them. So we want to try to protect our clients. So I'm going to hold on to your debit card and kind of dole out your money, you know, intermittently, so you're not spending all of your funds on substances. Certainly well intended, but still a violation of client rights. We can't do that. Um, Encourage them to engage in treatment, encourage them to engage in services, just make sure that we're operating appropriately. An example of inhumane treatment, and this is really good to talk about, is a deliberate attempt or an unintentional action or inaction resulting or causing harm. So if we see something that we recognize to be a safety issue or a concern for our clients and we choose not to act, that's an example of inhumane treatment. So we have to be diligent when we're working our clients and intervening when it's appropriate. All right, the right to receive services in the least restrictive feasible environment. This has been a big push, especially the last few years, making sure that clients are in the lowest level of care, appropriate and safely for their needs. So obviously, if a client, say, needs intensive outpatient treatment, we're not going to refer them for residential. You know, we want to make sure that we're providing recommendations and allowing the clients to have as much freedom as they possibly can while ensuring their safety. So we're not going to recommend the highest level of care off the bat unless that level of care is indicated for our clients. All right, the right to participate in any appropriate and available service that is consistent with an individual service plan, regardless of the refusal of any other service, unless that service is a necessity for clear treatment reasons and requires the person's participation. So what this means is we can't have services universally linked to one another. Clients can choose to accept one service and still choose to decline others. For example, we can't make having a psychiatrist a condition upon a client receiving case management services. If a client says, hey, I need a case manager, and we say, well, we think you would benefit from psychiatry or from counseling, we can certainly recommend those services and advise, you know, hey, we think this would be beneficial, but we can't tell the client they can't have a case manager if they decline those other services. Certain exceptions to this rule, you know, for example, if a client is engaging in residential substance use disorder treatment, and one of the conditions of the program is that the client attends so many 12-step meetings per week, per month, whatever the case may be, that's appropriate because that's a programmatic expectation, and that's how they measure the person's success through the program. Those kind of things are fine as long as we don't have services that are universally linked to one another. All right, the right to give informed consent and to refuse any service, treatment, or therapy, including medication, absent an emergency. And I love this definition. Clients can say yes when they mean yes and no when they mean no to all proposed services. That includes saying yes or no to being involved in research, having a payee, things like that. Clients get to make those decisions for themselves. It is important to remember when we talk about informed consent, that means the client understands what service is being recommended and is giving consent for that service to be provided. The informed consent, that means they understand the risks, the benefits, prognosis of engaging in such a treatment. All of these things are understood either by the client or a person with legal authority. That would be legal guardians. That would include for our youth clients or any adults that may have a legal guardian as well. Always making sure if the client does have a legal guardian that we're obtaining that informed consent from the guardian. All right, the right to participate in the development, review, and revision of one's own individualized treatment plan and to receive a copy of it. So it should go without saying, we aren't helping our clients if we don't have a solid treatment plan. And that treatment plan should be goals and objectives that were identified as helpful by the client. They should be actively involved in that process, understanding what their goals are, what they're going to be doing to achieve those goals, things like that, and then making sure we offer the copy of it or that the clients have the opportunity to obtain a copy of their treatment plan anytime that they ask for it. Some things that we sometimes see left out of the treatment plans that are usually really helpful. Any information about a client's medical needs, their doctor, their conditions, the treatment they're receiving for any kind of medical challenges. Volunteer opportunities, social activities, peer support, really, really big and important sources of support for the client and the community. Any cultural issues related to a client's wellness, recovery, and resiliency, and then issues like financial issues, helping them with budgeting, bill paying, recommendations for payees, things of that nature. I know we're going through this quick. I want to make sure we have time for everything. So again, please put questions in the chat. All right. The right to freedom from unnecessary or excessive medication and to be free from restraint or seclusion unless there is immediate risk of physical harm to self or others. So I always start this by saying I am not a doctor. I have exactly zero medical expertise and can tell clients exactly zero things as it relates to medication. So generally, I will always tell our clients, please take your medications as prescribed. You know your bodies, however, so if you feel that something is off with your medication, it's not helping, you're noticing significant side effects, whatever the case may be, again, we know our bodies. Have that conversation with your prescriber. Talk to them about those different issues. We had a case a couple years ago where a client was given for what they thought was too high of a dose of Seroquel. Anybody that may know, sometimes that medication can make you drowsy. So the client was like, I'm taking too much. I'm feeling, really drowsy throughout the day. So I'm going to talk to my prescriber. Prescriber disagreed and said, we think that this is the appropriate level of medication for you. So the client says, okay, well, I'm just going to self-adjust. I'm not going to stop taking my medication, but I'm just going to take a lower dose. I'm not going to take it all that's being recommended. So the prescriber learned of this and attempted to discharge the client from services, citing that they were non-compliant with their treatment. Was that a violation of client rights? What do we think? I see some head nods. Absolutely. Absolutely. We cannot ever discharge a client or treat them poorly because they were to self-adjust their medications. Again, prescribers are going to make recommendations. They're going to have their medical expertise as it relates to the client's well-being, but we also have to listen to our clients. We have to understand where they're coming from. Again, they know their bodies. Hey, this medication is making me way too drowsy. I can't stay awake during the day. All of these things should be taken into consideration. Now, restraint and seclusion. This is where things get a little fun. So I'm just going to put this out there. Unless your agency is certified to provide restraints, which means you are physically putting your hands on a client to prevent them from engaging in some kind of self or other harm behavior, Unless you're certified to do that, please don't do that. There are very specific trainings and things like that that staff have to go through in order to be certified to ever go hands-on with a client. First of all, it should only be a last resort after all forms of de-escalation have been unsuccessful. Secondly, there are ways to do it to make sure that when we do put our hands on clients, that we are not harming them or putting them at risk in any way. Most of the time when these things happen in these situations, these are for a lot of our youth providers that provide residential services. So a youth client is engaging in some kind of self-harm activity, not responding to redirection, not responding to de-escalation. The staff person may have to choose to put their hands on the client to, prevent them from injuring themselves or others. Again, you do have to be certified in order to be able to do that. Seclusion is putting a client in a space and preventing them from leaving. That is not really a tactic that's used anymore, including by most of our hospitals. They really try to avoid any kind of seclusion. So if you're working in an agency and a client may be having a behavior, or maybe having a moment, and we prevent them from leaving a space, that's seclusion. We cannot do that. We can ask them to leave common areas. We can ask them to go calm down or, take a breath somewhere. We just cannot ever prevent them from leaving a space. All right, we don't see this one very often, but it is a right, the right to be informed and the right to refuse any unusual or hazardous treatment procedures. So what this one is talking about is for any treatment recommendation or for any service that may be determined, quote unquote, experimental or potentially harmful, clients have to be given all of the detailed information prior to them choosing to engage in such a treatment modality. So really good example of this would be ECT, or the electroconvulsive therapy. I think Metro still has an ECT clinic. There might be a couple other providers around that do have the ECT. When we recommend this service, the clients are given all of the information as it relates to what are the risks, what are the benefits, what can I expect after engaging in this treatment, so that they can provide informed consent, and that they also have the right to refuse to participate in any of these unusual or potentially hazardous treatment procedures. One thing is noteworthy, this also includes participating in any kind of research study. I know we have a lot of universities around here that like to do their research. When you're approached and asked to participate in a research study, you have to have full informed consent. You have to know what's going to be happening within the study. You have to know exactly what to expect. Are there any risks associated with that? And if so, what are they? If you're ever so inclined, it's really fascinating to read some of the older research studies that were done before there were internal review boards, where we were actively engaging in like harmful behavior with our clients. And then some of the consequences for not having these review boards. These review boards prevent that from happening, making sure that when you are participating in a research study, that you're safe and protected while you're doing so. All right, this one gets fun, and this is where we always have a lot of questions. So please feel free, have your questions ready. The right to be advised and the right to refuse observation by others and techniques such as one-way vision mirrors, tape recorders, video recorders, television, movies, photographs, or other audio and visual technology. This right does not prohibit an agency from closed circuit monitoring to observe seclusion rooms or common areas, which does not include bathrooms or sleeping areas. So what makes this right fun is that we all walk around with one of these. We have cameras, we have video recorders, we have phones, we have everything. We have the internet readily available at our fingertips 24 hours a day. We have them, our clients have them. So one of the things that I like to start off by talking about is, so we are, many of us that work in the field, we are public employees, meaning work with the public. And I will preface this by saying I am not an attorney, so this is not in any way to be construed as legal advice or legal information, but in our roles and capacity as public servants working in the public, can our clients record us? What do we think? I see a couple heads shaking no. I see a couple. So the complicated answer to this question is yes, in some settings. Recording is prohibited anywhere that there is the expectation of privacy. Bathrooms, bedrooms, meeting with your doctor, involved in a therapy session, things like that. If I'm out in the community and a client records me as I'm engaged in whatever community activity I am in, there is nothing wrong with that because there is no expectation of privacy in public. So if we are in a public setting, there is no expectation of privacy. Now, let's say we're providers. Does that same courtesy apply to us as it relates to our clients? Can we record our clients in public? What do we think? I see some head shaking no. Correct. We cannot record our clients. Our clients are not public servants. Our clients have the expectation of privacy. So whether we're providing a service or not, we do not ever have the ability to be able to record our clients unless they're notified. If we need to record an interview, if we need to record a meeting of some kind, as long as there's no expectation of privacy, we can certainly let the client know, hey, I would like to record this. Would you be okay with that? The client can either choose to accept or decline. Again, this is not legal advice. Bill is not an attorney, so please don't interpret this as legal advice. So this right is really here to protect our clients and all of their intellectual property. So we're not taking pictures of our clients unless we have a photo release or their permission to do it. We're not using their likeness, their image, anything like that in any of, like on our website, on any of our promotional materials, on our agencies like social media, our Facebook or our Instagram. We're not using client images unless they have given written consent to be used for those purposes. Never should clients ever be on our personal social media for any reason. That includes things like artwork and any kind of intellectual property that belongs to the client. So if your client brings you a piece of artwork that's just beautiful, you love it, you really want to showcase it, you can't do that unless the client gives permission for you to publicize their work. And again, please also never include even their work on your personal social media pages. On occasion, some of you, may work for agencies where you may have students or interns. You may have certification people. You may have quality improvement staff that are kind of observing, the services that you're providing. That's perfectly fine. Again, the client has to be informed of who the person is that's observing, and they do have to give permission. Yes, it's okay for that person to be here for this service. Again, please remember you can have closed circuit monitoring, your security cameras in any kind of common areas, hallways, again, anywhere there's not expectations of privacy, can't have them in bathrooms, can't have them in bedrooms, things of that nature. So, please remember, be mindful of that. All right. Moving along, the right to confidentiality of communications and personal identifying information within the limitations and requirements for disclosure of client information under state and federal laws and regulations. So this is a really big one, and this is where things get a little muddy because then we start running afoul of state and federal laws. So we really want to make sure that we are always protecting our clients' health information. PHI stands for Protected Health Information. Our clients understand when, their medical records, anything as it relates to their health information is protected, and they understand who it is to be released and when, and that they've given written consent for that to happen. We're going to talk about this a little bit more in detail later on, so I'm going to kind of hold off on this one right now, but just making sure we're always protecting clients' confidential information, that it applies to all of their protected health information. Please also remember that a client's HIV status is also federally protected health information. So we're only disclosing HIV status if it's germane to the services being provided and authorized. Also, diagnosis and treatment for a substance use disorder is also protected under federal law. We're going to go over this a little bit more in detail in just a little bit. The right to have access to one's own client record, unless access to certain information is restricted for clear treatment reasons. So what this means is our clients can access their records anytime they want to and receive copies of them. The only time we can ever restrict a record, and again, we can only restrict a portion of it, would be if that portion is deemed harmful to the client. For example, during a therapy session, a client talks about in detail about a trauma. The clinician takes down some notes as it relates to that trauma and thinks, hey, some of these details right now may be harmful to this client. So I'm going to restrict this portion of the record if the client asks for a copy of it. That's perfectly fine. Just be mindful that in order for that to happen, you have to add the restriction before the client asks. If they ask for a copy of their record and there's no restrictions listed, then you have to release the whole record. You can't add a restriction after the client has already asked. It also has to be only a temporary restriction. We have to have a plan in place of how the restriction can be removed and what the client can do to have full access to their record. They can also access their record in person and visually anytime that they want to. So your agency should have a policy on how that happens if a client needs to come in and review their record. The right to be informed a reasonable amount of time in advance of the reason for terminating participation in a service and to be provided a referral unless the service is unavailable or unnecessary. So clients have to be informed, and again, a reasonable amount of time of why that we are terminating their participation in a service. The state does not specify what a reasonable amount of time is. So it doesn't say the client has to have 30 days or 60 days or 15 days. It doesn't say that. So it depends on the type of service, what would be appropriate. So generally the rule of thumb, if I'm doing an investigation, one of the things I'm looking at was there time for the client to secure services elsewhere? Did the client have access to what they needed during the time that they were advised that their service was going to be terminated? Those are the really important keys. Also, you must provide a referral anytime a service is terminated. Even if you know for a fact that the client is receiving services through another agency, still provide that referral because it protects you. The right to be informed of the reason for the denial of a service. This is very, very simple, just as it sounds. Clients have the right to know why an agency will or will not serve them. Anytime, like say that there's a grievance and we have to provide them with an alternative provider. Again, making sure that we do that, but clients understand we're not terminating your services, we're just making sure you're with somebody else. But again, clients need to be informed why an agency will not serve them. The right not to be discriminated against for receiving services on the basis of race, ethnicity, age, color, religion, gender, national origin, sexual orientation, physical or mental handicap, developmental disability, genetic information, HIV status, or in any manner prohibited by local, state, or federal laws. Whew, that's a mouthful for this one. Please don't discriminate against any of our clients. All of the listings there, these are things that are protected by state and federal law. These are protected classes of our clients. We cannot discriminate against our clients for any of these reasons. Please also note, gender identity is a protected class as it relates to housing and employment. As providers, we must provide housing and employment resources based upon the client's gender identity. So please keep that in mind. Just some things to know. We can never deny our clients services because they have like poor hygiene or a poor attitude. Denying clients any kind of services without reasonable accommodations, that can be discriminatory as well. So regardless of any class or affiliation, we are making sure that we are not discriminating against them for any reason. Again, these are locally, federally, and state protected classes, so just please be mindful. This one's pretty simple, the right to know the cost of services. Clients have the right to know what, if any, cost will be for the service that they're receiving. They have the right to an explanation and to know the cost before it's provided. So we're not going to provide them the service and say, oh, by the way, you owe us $1,000 for this service. No, that's not how that works. The client needs to understand before they sign on if there's any kind of cost or anything associated with the service that they're requesting. Also note, it is unethical for us to deny a client services solely based on their ability to pay. So just something to be mindful of. Watching my time, we're doing okay. The right to be verbally informed of all client rights and to receive a written copy upon request. Most of our agencies, they provide the client rights information when a client does their intake with the agency. Usually it's in a handbook. Sometimes it's, kind of a standalone packet, whatever the case may be. As long as clients understand when they're receiving services at an agency, they do have rights, and that they can receive a copy of the client rights policy anytime that it's requested. The right to exercise one's own rights without reprisal, except that no right extends so far as to supersede health and safety considerations. So we cannot deny a client service, treat them differently, be rude, ignore them, say we're not going to serve them anymore because they choose to exercise their rights. Even if you think the grievance is the most foolish thing that's ever been filed and you disagree wholeheartedly, forgive me for saying so, your opinion doesn't matter. We still have to allow their clients the right to exercise their rights. Then we cannot treat them any differently because they are choosing to exercise their rights. Again, any kind of safety considerations, we're going to make any sort of efforts and changes as we need to protect safety. But aside from that, we're not going to be treating a client any differently because of their rights. The right to file a grievance. Clients can file a grievance anywhere they want to. There's also no formal hierarchy. Here at the board, anytime a client comes to us to file a grievance, we always encourage them, hey, start with your agency first if you're comfortable. Every agency has a client rights officer. If you're comfortable, file with them. Sometimes our clients say, sure, I'll start there. I'll let you know if I have any problems. Others say, absolutely not. I don't want to do that. I don't trust them. I want to come to you directly. Clients get to make that choice. They can file with the agency. They can file with us here at the board. They can bypass us and go to the state. Disability Rights Ohio, the Civil Rights Commission, whatever the case may be, our clients can exercise those as they see fit with no formal hierarchy or having to go through any services first. Clients also do have the right to receive any assistance that they need when they're filing a grievance. If there's any kind of literacy challenges, if they need things explained to them, if they would like you to write the grievance while they dictate, all of these things are perfectly fine, and they need to have any help as necessary for a grievance to be written. We just kind of talked about this one, the right to have oral and written instructions concerning the procedure for filing a grievance and to have assistance if requested. We just kind of talked about that, making sure we're available and helping the client. The right to be informed of one's own condition. This one's pretty simple. I'm the client. I want to know what my diagnosis is. It doesn't help me in my recovery if I don't know what's being treated. So clients should know what their diagnosis is, risks and benefits of recommended services, prognosis, consequences of treatment. All of these things the client should be advised of. And the right to consult with an independent treatment specialist or legal counsel at one's own expense. So they can have any kind of second opinion from a doctor, a counselor, a lawyer, whomever. Clients can seek second opinions. However, they will be responsible for that cost on their own. There's also no requirement that the original professional accept the recommendations of the second opinion. So say I'm the prescriber and I give a client a specific diagnosis. The client says, nope, you're wrong. I disagree with that diagnosis. I'm going to go see prescriber B over here. The prescriber B gives them a diagnosis they think is more fitting. I don't have to choose to accept diagnosis B if I came to a different conclusion, but the client can choose to quit services with me and go meet with prescriber two, who they feel is more aligned with their services. Whew, that's a lot of information in 41 minutes. All right, so we got 9 minutes left. I want to spend a little bit of time talking about HIPAA and 42 CFR and some of our privacy practices, because these are really important. So HIPAA is the Health Insurance Portability Accountability Act. It's a federal law that provides privacy and security standards for your medical information. When you go to the doctor, anytime you receive any kind of medical care, your information is protected by HIPAA. That includes all things related to behavioral health. The U.S. Department of Health and Human Services is the entity that is responsible for enforcing HIPAA. Things that are included in HIPAA are a person's past, present, or future physical or mental health condition, treatment provided to a person, past, present, or future payment for healthcare an individual receives. And please note that this applies to any medium in which we would find PHI. Paper, electronic, oral, whatever the case may be, HIPAA applies to all forms of communication. All right, who are covered under HIPAA? So healthcare providers, obviously, those are your doctors, your dentists, your hospitals, nursing homes, pharmacies, all of these things are covered under HIPAA. Of course, these are your direct providers. Business associates, these are covered entities hire or contract with people and companies to perform services. The Adams Board is a business associate, so we are still a HIPAA covered entity as we have to comply with HIPAA. And the third is a hybrid entity. That means they provide both HIPAA covered and non-covered functions. So an example would be like a large corporation that has a self-insured health plan for its employees. They would be a hybrid entity, but only the PHI would be covered under HIPAA. Examples of organizations that are not covered under HIPAA. These are your life insurance companies, workers' compensation insurers, agencies that deliver Social Security or benefits. Most law enforcement agencies, that's important to know, our police officers are not HIPAA compliant entities. Child Protective Services, and then any kind of court case where PHI is relevant to the case. One thing that's noteworthy, an exception for HIPAA, it can be waived in cases of a crisis situation. If we have a case, a client that's in a crisis where we need to intervene, HIPAA can be waived in order to resolve that crisis. Now, that doesn't mean we just throw open the client's record and we just start throwing around all this PHI like it doesn't matter. We're only giving enough information to help resolve the crisis, and then HIPAA is right back in place. But again, we want to protect the client. So if we need to share information to protect them, HIPAA does allow you to do that. 42 CFR, this is chapter 42 of the Code of Federal Regulation, part 2. It is the federal confidentiality law that protects those that are applying for or receiving substance use disorder treatment. The reason that this law was enacted was, by and large, the way, at least they viewed it at the time, by admitting a person has a substance use disorder, a person is in essence admitting to engaging in criminal behavior. They found that a lot of clients were very reluctant to engage in any kind of treatment because they were fearful of any kind of legal repercussions. By putting this law into place, it protects our clients, allows them to seek treatment without any kind of fear of legal consequence as a result of them seeking treatment. So that protects all of their information while they're engaging in that treatment. All right. 42 CFR, it does allow disclosure of information, but only in very specific instances. Crisis is not included, only medical emergencies. Goodness forbid, if we have a client that's engaging in what we believe to be an overdose, that's a medical emergency. We can share if we believe the client took a substance. Any cases involving child abuse or neglect, we can report a client's crime on program premises or against program personnel. Now, if we have a suspicion a client is dealing drugs out in the community, that doesn't count. You cannot disclose that. if we catch a client dealing drugs on our property, while they're receiving services, that's on program premises. We can report that to law enforcement. Any qualified audit or evaluation of the program, that's going to be your CARF accreditation, our quality improvement team here at the board, things like that. Court orders authorizing disclosure and use of the client's records. So really good example here at the board in client rights, we get a lot of contact from law enforcement, from investigators with the prosecutor's office, like, hey, I need you to tell me any information you have about this client. So if it's mental health related, I tell them, get me a subpoena and I can share with you the information that you want. If I find that the client is receiving substance use disorder treatment, a simple subpoena will not suffice. You do not have to disclose. In many cases, again, Bill is not an attorney, this is not legal advice, but in many cases, a subpoena for substance use disorder information will not suffice. You need a 42 CFR compliant court order, something with a judge's signature that indicates that it's 42 CFR compliant. All right, so what are the differences between them? In the last 3 minutes, I can do it. I have faith. So the primary difference is that HIPAA applies to many types of information, not just SUD records. HIPAA is also generally considered a little less protective when it's compared with 42 CFR. Another difference is the privacy protection for clients' records in criminal and then civil legal proceedings. Again, we talked about that. 42 CFR requires a specific court order for the disclosure of any records pertaining to SUD treatment or services. And it's because SUD records could potentially expose a client to criminal liability or legal consequences. HIPAA also permits disclosures without client consent for treatment, payment, or healthcare operations. Part 2 requires client consent regarding any sort of SUD treatment records. And again, we talked about this. HIPAA can be waived to assist clients in crisis. 42 CFR requires a medical emergency in order for that to be waived. Oh, a minute to spare. Man, I'm good. All right, we covered a whole lot of information in a really short period of time. So here's our contact information. I know my friends at NAMI are going to put this up, so you're going to have access to it. Please know, whether you're a client, whether you're a provider, whether you're a friend of the community, whatever the case may be, anyone can reach out to Client Rights at any time for any questions. We're more than happy. We are here for you. If we don't have the answers for you, we will tell you who does. So with that, I
Bill,
will.
thank you.
Yeah, absolutely.
Yeah, that was amazing. That was so much information. We really appreciate having you here. Someone who can go through 21 points coherently and cohesively. That's very difficult. So thank you. I am going to go ahead, just real quick, I'm going to post our helpline number, the NAMI helpline number, in the chat, as well as a link to what is called paper survey. So we do ask when individuals attend a psychoeducational webinar with us, if they can please take the time to fill out this survey. It's very, very quick, and it just helps us get a good idea of who we are reaching for these types of things, and maybe where we might need to reach also to get more people in attendance. So I'm going to go ahead and post that, but then we've got a few questions in the chat. So Bill, someone asked initially, are there agencies similar to Adams in other states like California and Michigan?
So the simple answer to that question, I'm embarrassed to say, I don't know. Um, United States is wonderful. Every state does behavioral health differently. It's just so complicated. So unfortunately, since everybody does things so differently, to my knowledge, we're the only state that does Adams specifically. Other municipalities, they do have, different oversight bodies. I just unfortunately can't tell you specifically about California or Michigan. I'll tell you what, email me. My partner officer, Diana, actually came from Michigan. That's where she was providing direct service. So she'll have a direct answer to that question. My email is here on the PowerPoint. Shoot me an email and I'll have Diana provide that information to you.
It's a wonderful connection. Thank you, Bill. Um, our next individual asked, how does number three, which is the right to receive services in the least restrictive feasible environment, play out now that the Department of Justice has said states don't need to provide home or community-based services to people who need support? And this individual says, I know the DOJ memo just came out, but I'd love to hear your opinion on what might happen next here in Cuyahoga County.
So one of the greatest challenges with all these changes coming down at the federal level, we're all learning as we go. I'll be really honest, it is a little frightening when we're looking at some of the possibilities. And this has been part of our discussions in our public board meetings. All of our agencies are being asked to do so much more because the need is continuing to grow with less money and with less resources. And it's so difficult to be able to do that. Generally speaking, federal law always supersedes state. We all know that. However, client rights is part of our state statute. From my perspective, that's not going to change. When we talk about the least restrictive level of care, we are still going to enforce that here in Cuyahoga County. We're still going to make sure that, clients are receiving appropriate care for their needs, appropriate care for their safety. But again, we're not going to be putting people in situations where we're taking away their freedoms unless it's absolutely necessary. So I don't foresee that piece changing. That's part of the ASAM criteria, the American Society for Addiction Medicine. That's a really big piece of what they're doing. Again, making sure that there's appropriate level of care. Same thing for mental health. In certain situations, like when we have to probate clients, unfortunately, things like that. Again, we are taking away a person's freedom when that happens. It's a court order that involuntarily commits them to the hospital. Those same metrics are still going to be used. We're still going to look at, is this necessary? Is it absolutely important that we do this before we take away somebody's freedom? So from my perspective, this doesn't change. We're still gonna be enforcing, these policies as it relates to least restrictive feasible environment. As far as the Department of Justice, again, I'm so sorry, I don't know. But I am going to continue to operate the way I have been operating for the last 9 years, and until somebody tells me different.
Well, and it is so hard to know because things are changing so incredibly quickly. So, yeah, that's thank you for answering that. So our next question is, what about case management for individuals who have private health insurance but have very limited mental health coverage? Co-payments are going up, and that's making it extremely hard to maintain accessibility. What are some options?
So the best options with these kind of situations is really agency dependent. Most of our agencies, they do have a variety of different programs, sliding fee scale, some different forgiveness programs, things like that, where we're going to try to offer you services at the least possible cost. Again, like I said, it is a violation of client rights for me to deny you a service only because you can't pay. So, we need to avoid that. If there are issues with insurance, then first of all, we need to have a discussion with that agency's finance team, see what is available to assist that person. If the agency, for whatever reason, is not able to provide the service at a cost that's reasonably affordable to the client, then they are responsible for providing referrals to another provider that can. We also have a program here through the Adams Board. It's called pooled funding for a variety of circumstances for our clients that don't have insurance, that maybe have insurance limitations, whatever the case may be, where our agencies can actually bill the Adams Board for services while we're getting Medicaid established, while we're looking at different options. So plenty of options are available. The best thing to do to start is to talk to your agency's finance department. Really good question.
Outstanding. There are no more questions in the chat. Um, does anyone else have any questions? see. Well, I have a question, Bill, if no one else does. So I am wondering about kind of how does someone end up with you as opposed to making a complaint with a licensure board? So is there a time, kind of what's the difference? And is that something you assist individuals with? Or kind of, those are two things, but I'm wondering how that converges with you.
Yeah, absolutely. Oh, good question. So, the first part to answer it is if yes, we will absolutely help you file a complaint with the licensing board. We've done it before. Forgive me for bringing this up again. If you have a romantic relationship with your client, you better believe I am sitting there with the client. We are filing with every license you have. Please don't do it. Um, there are occasions, in different circumstances, like we do get the occasional complaint from a client like, hey, my prescriber is recommending this or gave me this diagnosis. I strongly disagree with that. I'm not a medical professional. So I can look from a client rights perspective and say, yes, they did their due diligence. They did an appropriate assessment. They did the right things. Um, we will likely tell them, hey, your best bet in this case, don't file with me, file with the person's license. I will help you do that, and then we can move from there. There have been occasions when we've done both, where we do an investigation, hey, we're going to investigate. Your allegation is particularly egregious. Go ahead and file a complaint with the person's license as well. We had a case not too long ago. The client was visually impaired, had a pretty significant visual impairment. Went through this whole thing, selecting a home, was really excited. Everything had gone through until the potential landlord, when they signed up to sign their lease. The landlord saw, oh my goodness, you're blind. I don't want the liability. I'm not renting to you because you're blind. So that would be holy discrimination, Batman. So we assisted the client with filing a civil rights complaint. The client actually received a $50,000 settlement because the landlord had engaged in discriminatory behavior. You can't do that. So we're going to evaluate every case, that you bring to us. If you have a question or a concern, we'll tell you, hey, this is for us. We're going to investigate. Probably better off going here. Let's do both. Come into my office. We're going to fill out this complaint together. I'll show you how to do it. So we're going to evaluate each one case by case.
That's outstanding. I think that's such a great form of advocacy where it's I am available to you and I will help you figure out next steps, even if I'm not the next step. That's a really powerful thing. And thank you for doing that for so many individuals in our community. You are very appreciated.
Thank you.